Hi, I'm Steve Schindler.
I'm Katie Wilson-Milne.
Welcome to the Art Law Podcast, a monthly podcast exploring the places where art intersects with and interferes with the law.
The Art Law Podcast is sponsored by the law firm of Schindler, Cohen & Hockman, LLP, a premier litigation and art law boutique in New York City.
Hi, Katie.
Hi, Steve.
So, we're here with Joan Kee. Joan is both a lawyer and an art historian, which is perfect for the Art Law Podcast, I think. Joan was a practicing lawyer in New York and Hong Kong for several years before she decided to go back to school and become legitimate and get a PhD in art history. And now she's an associate professor in the history of art at the University of Michigan. And we're here to talk to her today about her new book, Models of Integrity, Art and Law in Post-Sixties America. Welcome to the podcast, Joan.
Thank you.
So tell me a little bit more about your background and how it was that you came to write Models of Integrity.
I majored in art history as an undergraduate, and my field was modern and contemporary art. One of the things that struck me was that, say, from the 1960s onwards, that art became much more complicated, more difficult to execute, that we talked in class a great deal about, say, land art. So art that uses vast tracts of land or engages, say, extensively with the world outside the museum or the gallery, and that was the art itself. So thinking about art and part of the everyday. And I always wondered about things like insurance or, say, waivers, just because my father's an economist, and I grew up with a T-shirt that actually read, "Risk management is life." So when I took these classes, I would always ask, well, how did the artist get permission to do X, Y, and Z? Because I know if I try to make artwork out of a deserted piece of land that...
And who does that land belong to?
Exactly. So these are sort of questions that have always lingered in the back of my mind. I went to law school immediately after undergraduate, which was not a course of action I would recommend for everyone. One of the reasons being is that, so I went to Harvard for law school, which at that time actually did offer a course in art law. It was one of the only schools I know that actually did offer that. And much of that class was focused on constitutional issues, freedom of expression, or cultural property, in large part because, again, the idea of art law. So it's not really a solidified field, as Katie and Stephen, you know very, very well. It's something that's cobbled together from, say, labor, employment, contract, torts, all different fields or subfields of legal practice. And one thing that I've noticed with that class was they tended to treat artworks as objects, as physical objects, when in fact, most of what we know, or from my own background, when we think about contemporary art, it's actually thinking about immaterial works, performance, installation, collaborative practices, works that were never intended to result in a final physical manifestation of a thing. So I was always thinking about, okay, so how do we think about the law in relation to the majority of what is considered to be sort of the highest expressions of contemporary art? But the two didn't really click together until many, many years later, in part because, again, that the way that the art law field, and I use field very loosely, has developed, now you can actually have a career in art law practice. You have law firms that actually have whole fields and areas of specialization.
We try.
But 20 years ago, now I am disclosing my age indirectly. 20 years ago, I said, well, could I have a art law practice? And my professor said, well, you could do pro bono, but you can't make a living off of that. Maybe you could be a director of someone's estate or work at a museum, but that was pretty much the extent. Now, I realize this is something of a long segue into explaining why I wrote this book, but I don't think it would have been possible to write this book, say, 20 or even 10 years ago, in part because you didn't have, say, the critical mass of interest from the law side about what is the place of art, but also the place of culture on the one hand. And then now, say, in this intensely politicized climate, that there is a real interest in thinking about art and politics beyond, say, meaning or beyond, say, gestures of protest, and more along the lines of, well, what allows art to exist in the way that it does today? And in many ways, you can't have contemporary art without thinking about the law. So law, in many ways, is contemporary art's fundamental surround. Any work that's made today, law is involved, whether it's through contractual obligations or whether it's through questions of negotiation which arise frequently, or, say, tax law. So even though I am officially retired from the practice of law as per the New York Bar Association, I get about 2 or 3 requests per week from artists who are not U.S. citizens who ask about tax all the time. These are questions that come up with increasing regularity because we live in such a globalized art world.
And I think it's still difficult for a law student coming out of law school to have a full practice of art law. I think that doesn't really happen. You need to go do something else, pick a related specialty, and find your way there. I mean, I think it's still not robust or lucrative enough, for that kind of entry out of law school into practice, but certainly many more students and lawyers are aware of it, and many more people are practicing. I think it's interesting that, the way the art law field really began in private practice was through tax and private client groups who were dealing with wealthy individuals who had art that either wanted to dispose of the art, think about how to deal with their estate. And there are so many tax issues around personal property, and art being a very expensive example of personal property. We don't practice tax, we don't do estate planning, but we're very aware that this field, in some ways lives in that practice and started in that practice in many ways. But maybe you can talk a little bit more about the subject of your book, and if you think there is a central thesis, or what your message is.
So something about art and law. So that connection has existed for centuries, that we have lots of scholarship about, say, Raphael negotiating contracts with his patrons. But one thing that was very telling is the reason why the book especially starts in the 1960s was you had so many artists wanting to work outside the traditional realms of the gallery or the museum. And many of these artists had to involve law in some way, that you had artists actively reaching out to lawyers to collaborate on projects. One example might be the artist Suzanne Lacey, whose retrospective at SF MoMA, I think it just closed or is about to close, that she had actually contacted volunteer lawyers for the arts, or at least the analogous organization for that in California, to collaborate on a work called Body Contract, which came out 1 year after Roe versus Wade was decided. And in it, what she did was to price all of her bodily organs. So it wasn't the organs that were necessarily for sale, it was selling the right to dispose of the organs as she wished. This was actually a comment on the healthcare system. She says it wasn't about Roe versus Wade at all, but again, that correlation is very prominent.
Actually, and you talk about her a lot in your book, and another piece that she worked on called 3 Weeks in May, which I thought was really interesting too, was another inroad into the legal process through the mapping of, I believe, places within a geographical area where women were raped in the 1970s.
That's correct. And 3 Weeks in May was interesting for me because often the way in which the art and law relationship is characterized, especially from, say, the art side, and by this I mean artists, art historians, critics, curators, is that the law is something that does something to art, and it's usually something not good. That law is an instrument of oppression. But 3 Weeks in May is unusual because it was a collaboration between the LAPD and Lacey to track all of the rapes that had happened, to raise awareness about a crime that was widespread and still is, to implicitly perhaps bring about some change in the legal system. So the book is structured around 3 general nodes. So one would be legal practice, another would be legal theory, and the other would be something that, for lack of a better term, would be called the artistic imagination. So I wanted to focus on practice. One of the reasons being is that both art and law involve extensive interaction between human beings who, despite the influence of law and economics on the study and practice of law, human beings are fundamentally irrational, and artworks perhaps prepare individuals for that irrationality. And that sort of give and take of that human interaction is something I wanted to emphasize. The other was legal theory. Katie, you and I spoke a little bit about this before this podcast, about artists perhaps having to be accountable to extra artistic standards. And those standards being, say, legal or ethical in nature. This is something that becomes increasingly prominent from the 1970s onwards. Right before I came here, I actually did a Google Ngram search for the terms litigation and lawsuit. And from the 1970s, it just skyrockets. This is something that is also very much symptomatic, again, of how art inevitably becomes embroiled in, say, tensions that have to be resolved through legal means.
One of the interesting things that threads throughout your book is this tension between artists rejecting the law or, ignoring the law and using it as a tool. And that both of those things are happening in this period with different artists. And I'm wondering if you can talk a little bit about whether there is a fundamental tension or incompatibility between artistic practice and, thinking about the rule of law in civil society. And if that is, why would that be? Or if that's just sort of a fiction, of some artists or some art historians, and really for most artists that's not a fundamental incompatibility.
I think it can vary. So one example where, say, the incompatibility doesn't necessarily apply would be, say, with Chinese artists. The book focuses mostly on U.S. examples, but looking ahead at, say, future projects is to think about art and law in different jurisdictions, because I think that's going to be a real challenge as artists move from place to place or have simultaneous residence in multiple countries. Is, for example, with Chinese artists, that transaction now becomes the paradigm for relationships. So in the past, when you had different artists striking up bargains or agreements because they happen to be friends or neighbors or relatives, now it's all ruled by, say, transaction, and especially through contracts. One would be hard-pressed to find a demographic more attuned to the U.S. legal system than, say, Chinese artists whose works
That's fascinating,
sell
because
for.
U.S. artists virtually never use contracts when they sell their work. That's really interesting.
And so I also wonder, in terms of, say, the lack of compatibility between art and law, I think that does apply to certain artists for whom violation is a fundamental part of their practice, that they see that certain laws are not enforced. I talk a little bit about artists who commit petty crimes or crimes that the law does not see as worthy of prosecution. For them, their idea of what comprises interesting or compelling artworks is based on how is it that art can make a space for law to reflect upon itself and to reflect upon its own limits. But at the same time, I think the vast majority of artists, they don't really come into contest with the law. I think that tension is certainly there, but it's not, say, uniform.
Where does that come from, that sense that the legal system, rather than the whole mix of things, that it is liberating, oppressive, inspirational, depressing, like all the things that law has enabled and continues to enable? Why is it that artist or artistic practice tends to gravitate towards seeing law as constricting, or at least the examples that you provide in the book?
Everybody likes a good fight. Everybody likes, the black and white, the binary is still something that has a great deal of appeal. So, the helpless, oppressed artists against the big, bad arm of the law. I mean, that's still a narrative that gets rehearsed over and over again. But that's also based on a very narrow understanding of the vastness of law. I mean, to say that law is unequivocally bad is like saying air is unequivocally bad.
It's so interesting to hear that, because in New York State, and I think is true in California as well, and maybe many other states in the United States, the law around cultural production is very protective of artists, the default laws in New York, and much more so than it protects dealers or collectors, other players in the financial art world. And yet, even though it is one of the most progressive statutes in terms of protecting artists, artists rarely utilize it or educate themselves about it in New York. Now, maybe that's changing a little bit, and there are definitely exceptions to that, but I do think generally the law is very progressive and artist-friendly in New York, and yet artists are not engaging it to their benefit. And, I think about those examples where I wonder if a prior assumption or predilection to be contrary to all kinds of legal forms actually ends up hurting artists because they're not utilizing the law to their benefit.
And I think that's also based, again, on that very sort of narrow view of not only what law is, but what also law can do. In terms of, say, artists trying to utilize the artist-friendly nature of law in New York State, an example might be someone like Aviva Ramani.
Yes, we had her on the podcast, actually, yeah.
Her work is actually based on a precedent in Canada. So a man named Peter von Tiesenhausen in Alberta put up a segment of white fence, which is actually based on Christo and Jean-Claude's running fence.
Yeah.
So this is also thinking about connections. And mining companies wanted to buy his land, or at least buy the rights to drill into his land for the oil. And he was able to stop them by saying, well, my land itself is an artwork, in part because Canada has stronger moral rights protections than the United States. But this is something that sparked the imaginations of other artists. I know that in addition to Aviva Ramani, there are other artists, say, in places like China or Japan that have been trying to claim, well, the land is my artwork, therefore these other interests can't come in and just regard the land as something that they can exploit.
Yeah, and to add more detail to those contexts, the issue that Aviva, she's working under a federal statute, which is the Visual Artists' Rights Act, which provides the minimal moral rights, non-economic rights that artists have in their cultural production in the United States, meaning an artist may have a right to a physical object that someone else owns. It's a very strange concept for most people to think about. So Aviva and other artists are working to create art on land they do not own to prevent the destruction of the land, the mining of the land. It'll be really interesting how courts deal with that. My guess is it won't go anywhere in the United States, but
It's a good guess. But it's interesting. So that's an example of an artist that is using the law for an activist purpose. And there are other artists, of course, that also are interrogating the law in different ways. There's a quote that I stopped at it in the introduction to your book because, as our listeners know, this is a podcast exploring the places where art intersects with the law. We say that every podcast. And then I'm reading your book and I'm quoting. It says, "This is a book about art that, quote, messes with the law, as well as law that calls into account various assumptions underwriting artistic production." So how, in your view, does art mess with the law? And who are the artists that are doing it? I mean, I can think of a couple. I'm not sure that you touched on them. Cameron Rowland, for one, sort of messes with the law. Titus Kaphar is also now messing with the law, and particularly his most recent exhibition, Redactions. Is that the kind of thing that you're referring to, or is there something else?
So one example that I talk about in the book that also might be timely. So Gordon Matta Clark has a couple of exhibitions that are on right now. One is in Montreal, and I think there's another here in New York. So when Gordon Matta Clark, very active in the 1970s, what he did was to illegally take one of the crumbling, abandoned piers. It wasn't legally abandoned. The city of New York still owned the pier, but what he did was to cut out these giant orifices, sort of these half-moon or sail-shaped holes in the side of these buildings. For him, the way I see his work, rather than thinking about it in terms of vandalism, that was the NYPD's approach to what it is that he did, was rather that he was trying to shift the conversation from thinking about everything in terms of property. I own this, therefore you are excluded from coming onto my land or onto my property, and thinking more about how do we turn property into something of a commons, something that can be shared or used for a wider good, that it wasn't just going to be isolated to one particular specific owner. So that would be one way of thinking about art messing with the law. Another would be, say, artists who deliberately violate the law or call attention to areas that the law has not yet addressed. In another adjacent project, I talk about Yoko Ono. So we all know Yoko Ono. We unfairly accused of breaking up the Beatles, but in 1969, she made a film where she had a cinematographer follow an illegal migrant for an entire day. And in theory, this migrant young woman was supposed to be paid. I don't think she ever was. But this cameraman just followed her through the streets of London for about a couple of hours. He never touched her. He never spoke to her. He just followed her. And this is at a time when stalking was yet to be criminalized. But the terror that this young woman registered on her face and through her body language made very clear how certain everyday acts that perhaps the law at that time would have considered innocuous, was something that maybe should be subject to legal scrutiny. An example I do talk about in the book would be J. Jaroslav. So J. Jaroslav was a conceptual artist. He also worked for the CIA. And he was able to get documents from Boston City Hall and essentially forge entire identities using the certificates of babies who had died at birth. So he used the birth certificate to obtain a driver's license, used that to obtain a voter's card, used that to then, I don't think he actually obtained a passport. But he was able to create these fictional identities at a time when the idea of identity theft had not even existed in, say, either the legal or political realms. And so in this way, it's not a direct violation or quibble with the law, but it's a way in which, if we think about, say, how this book might intervene in thinking about what it is that law can do or can be, this is a way in which artists are saying, hey, maybe you should really pay attention to this. Maybe that art has some sort of predictive value. I don't want to go so far and to say that all lawyers should study artworks to glean some nuggets of wisdom about how to run their law practices. But
it might help.
But the tensions between art and law might be something worth thinking about, especially if we want to consider how it is that legal practice can better accommodate for the irrationality of how human beings behave.
I think it's so interesting to me that you recount this sort of rich history and ongoing practice of engagement between artists and legal structures in the two, I think, opposing ways we've talked about, either using the law and engaging with it or violating it and rejecting it. I see those as different, but obviously related in the sense that artists are engaged with the identity and existence of law. As a practitioner, my overwhelming reaction from the legal perspective, not from artistic practice, is that the art world still does not engage with the law. I mean, from collectors to dealers, certainly mostly artists. My, day-to-day experience is that the problem is not that these players are engaging with the law or critical of it. It's that they are ignorant of it, or not even ignorant of it, just not willing to engage with it at all. And among art lawyers, I think that is a common observation, that it's sort of an extra legal industry. It's not professionalized. There are other words you can use in the way that other industries are that have legal systems, contractual systems in place. And the art world is unique in that it really doesn't for such a high value industry. So I don't know that your book deals with that at all, but it just was something I was thinking about as you were painting these rich examples of legal engagement in the art world, that, in legal practice, it's often the absence of engagement that we notice.
Absolutely. I do touch a little bit about that, especially with the first chapter on the Sigelab Agreement. So it was one of the first attempts to
please
really
talk about that.
Try to harness contract law to address or engage with the issues that artists faced on a daily basis. Things like, what happens when my work is sold? Do I still retain copyright? And of course, the infamous resale provision.
Our listeners may not know the background of any of this.
So it's commonly known as the Sigelab Agreement, but what it was a collaboration between a curator/critic/promoter named Seth Sigelab, very well known for promoting conceptual art and really putting it on the map of the contemporary art landscape in both Europe and North America, and with Robert Perjansky, who was a lawyer and also had extensive experience working with artists. And what it was... And
in the 70s? Was this in the 70s?
This was in 1970.
Okay.
And what it was supposed to be a standard issue agreement. It's not terribly well drafted. For those of you who are contract nerds, the wording is very clunky. Perjansky himself said, I just churned it out in a big rush. And it's most famous for what's called the resale provision. So meaning that when an artwork is sold to, say, another buyer, and that buyer then resells the work to someone else, if a profit is made, a cut of that profit would be then returned to the artist. Now, that provoked a widespread outrage. It was considered a tax. It was considered something that no collector would agree to this, and that has largely been true. But what was important about that agreement is not so much that it failed to become industry standard, which was Siegelob's hope, but rather that it really started to get artists thinking about, well, what are my rights? What are the basic sort of things that I need to function as an artist in this rapidly expanding industry? Because the early 1970s also marked the time at which the art world expanded in terms of, say, not only sales, but the kinds of artworks that were sold, the kinds of collectors, the places in which art was sold. So how is it that contract might allow artists to function more readily in these situations? But as you know, Katie and Stephen, very few artists use contracts. The ones that I know who do are the ones who need them the least, the ones who already are successful.
Sure,
Yeah.
right. And that's true. Obviously that was an attempt to introduce through contract what exists in Europe in terms of artist resale royalties. Some people here have tried to introduce into the federal legislature for a number of years without any success. And you're right, this contract really just sort of died. It's interesting that you mentioned the growth of the art market, because I was reading your book, Models of Integrity, kind of alongside a recent book by Michael Schneerson called Boom, which traces it's really the history of the art market, and particularly mega galleries from the early 1960s to the present. And I was struck by this concept of the hunt for integrity, which you sort of so deeply focus on, and what might be called something else that was happening in the art market. I don't know what the word is, but it's definitely the influx of money, the increase of
Sort of status.
And that there's some tension in this notion of the artist as the force confronting oppressive laws and other examples that you give, and the increasing sort of influx of money and of art becoming much more expensive.
I think what you're touching upon, Steve, is that artists were complicit in that system, right? Because the
Yes.
art world doesn't take off
That's right.
and become, a 7-figure per work industry without artists getting on board with that. And so that world, that commercialization of the art world, is happening at the very same time. Or maybe there's an overlap. It may not be developing at the same time. One may be dying as one is growing. But, the 60s and 70s are certainly a decade where you're seeing a lot of experimental, non-commercial art, and maybe in a moral and ethical call to that kind of work, away from the gallery, away from the collector, at the same time as the commercial art market is taking off, and artists who are recognized and, praised are entering that system willingly. And that's still a tension. I mean,
I got
see that
so
now.
much flack for using the word integrity by certain of my friends. But the way which, for me, integrity works, the reason why I use integrity is not necessarily to say that these artists are, say, morally superior, or even that their artworks are useful. So integrity for me means three things. One is consistency of purpose. Purpose doesn't have to be grand or even laudable. It just has to have some sort of continuous purpose that exists despite challenges or setbacks. That's one. Another is, how is it that you can self-actualize? So the 60s, 70s, and 80s, it's a time when artists are really grappling with, well, what is an artist? Are we the lone romantic genius? Are we, say, a blue-collar worker? There was a real sort of impetus to align artists with blue-collar work. Are we, say, entrepreneurs? Are we, say, businessmen and businesswomen? What are we? And so integrity for me also signals a time in which artists were really trying to think about what confers onto ourselves a sense of identity. So going back to another pressure point, which Katie, you raised earlier, whether artists should be treated as privileged or special, or rather, is that kind of special treatment justified? I think this is also a question that is one of the fault lines between, say, art and law. So on the one hand, the law treats, at least until the mid-1970s, art was just like anything else. It was like a pair of shoes. That was one of the quotes that has resonated with me. But on the other hand, with moral rights activism, that there is also simultaneous pressure to think about, well, artists maybe should have special non-economic rights because of the work that they do.
Unlike a shoemaker or a furniture maker.
Exactly.
Right.
Now, my own take is that I'm very ambivalent about moral rights, in part because if, say, an artist wants to intervene or engage with the everyday, you kind of have to roll with the punches. That means you're going to have to subject yourself to standards of, say, the outside world. You can't have it both ways. Now, there are other scholars, one of my favorite scholars, Amy Adler, who talks about the market.
Who's been a guest on the podcast as well.
And who has been, for me, a formative influence in thinking about art and law. One of the reasons being is that she's one of the very few legal scholars to engage directly with contemporary artists. Not from the position of a legal scholar giving advice, but thinking about how do I have some sort of sympathy with the artist. And she talks about, say, the market as perhaps a better arbiter for dealing with the issues arising from moral rights questions. I'm not so convinced about the market either, in part because I also, in my other work, deal with artists from countries where the free market doesn't exist. So places like North Korea, for example, or places like China, where the free market is there, but it's also very, say, fragile or contingent on certain political situations.
Well, and there's a fraught history of intellectual property protection, which is, in Amy Adler's part of her argument is that copyright in all of its forms may not really be necessary anymore in the art market. The market may do that regulation. So the idea of authenticity or who owns the copyright may not be particularly useful anymore. But as you point out, really
It's
interesting in a place where there aren't those rights.
It's assuming that the market works perfectly, which it doesn't in most parts of the world. I also wanted to touch upon, Katie, your question about, say, the art world as not functioning along the same lines as the legal realm. And so in the book, one of the tensions that has been very generative for me is the difference between law and norms. So that the art world does have its own set of standards.
Absolutely, right.
But they are really what would be called customs. They're unlegislated. They're not really written down.
They're handshakes.
They're handshakes. It's
Winks.
kind of informal agreements. There are, say, consequences if you violate, say, certain agreements, because the art world is a relatively small place. So even though New York, just to take one example, it's a big place, lots of multiple art worlds, or art ecologies, rather. Say if you violate certain agreements, that can also prevent you from operating in your given art world in the way that you want that operation to happen. So it's not as if, say, you can behave with impunity in the art world. There are certain consequences. It just doesn't really align with, again, how, say, those of us who practice law would want or would expect artists or collectors or galleries to act. And this is very frustrating because, again, there isn't much transparency in the art world. Whenever there's a new book about the art market, there's a long sigh. One is because most of, say, the literature about the art market, it's based on auction prices, which are disclosed. But the auctions only represent a tiny, tiny fragment of the entire art market. None of the, say, gallery prices, most galleries, they're not going to say, well, I flipped this work for double what I paid for. And that, in fact, is really sort of the meat of what's happening in the market. And this lack of transparency, I think this is also something that artists struggle to deal with, especially if you don't have the clout of a major backer. If you're not institutionally recognized, how do you kind of find your way in?
Sure.
Yeah.
And the lack of transparency, which is something that, we here talked about and we talk about a lot, also has a great impact on art as an asset class, art as a thing that is bought and sold, because there are great inefficiencies in a market where you really don't have access to a lot of information, and where access to information is something that is precious and that is, in effect, sold, to unwitting customers sometimes.
I want to talk about another aspect of integrity. So when we, as lawyers, hear integrity, we think about it in a legal sense, in the moral rights sense, which means that you have a right to a certain amount of control over your work and what happens to your work. And there are limited integrity provisions in the Visual Artists' Rights Act in terms of destruction of an artwork if the artwork is of recognized stature. And we've done an episode where we go into more detail about that in the past. That effort by artists, I think, to have more control over the non-economic rights in their work, to protect their copyrights, to have a resale royalty, are very capitalist instincts, right? They strike me as smart and rational and very much in tension with a lot of the examples in your book about artists rejecting that system of ownership, of property, of mine versus yours entirely. And I wonder how you sort of square that, reject or blow up the system with, actually, I'm going to fight for all these things, within the realm of that system that reinforce this idea of personal property rights.
I think that paradox resides in almost every artist I know. So a lot of artists like to say that I want to reject this exclusion paradigm on which the idea of private property is based. But on the other, when it comes to what might happen to their work, artists are very quick to think about what are sort of the tools at my disposal. I've noticed a decided uptick in artists who are very aware of their copyright, to the point, just to give an example that encumbers all scholars. So, for example, fair use. Fair use is something that legally would allow scholars to use images without having to necessarily seek permission. Now, to my understanding, I don't know of any art historian who's actually trying to put that to the legal test. I don't know of a trial in which an art historian was sued by an artist on the grounds that he or she misused an image of theirs. But I've noticed that if you ask an artist for permission to use their images of their work, what has increasingly happened is that they ask for a copy of the text, and they want to approve that text before they release permission. I understand where that's coming from, the desire to protect how their work is going to be presented and circulated. But say for scholars, to me, it also can come across as a form of hostage taking.
That flies right in the face of the concept of fair use, where works are supposed to be subject to criticism and to discussion.
And this is something that is a real challenge for anyone who uses visual imagery in their scholarship, and especially so for those of us who are art historians or curators, and for whom, if we don't have images accompanying our text, the text diminishes in its impact. And so this is also a question that has become much more prominent in, I'd say the last 5 to 10 years as artists become more aware of their rights. And I'm also struck by the knowledge base of artists for whom the law is really about copyright or resale provision or something to do with the idea of property rather than the vast panoply of other laws that I think were much more visible or legible to artists, say, in the 60s or 70s.
And that those types of law would be what? More liability issues or
liability issues,
restrictions on movement or offense or
trespass. To what extent can you, say, perform a certain action without becoming criminally liable? How do you deal with, say, negotiation? This is also something that for me has been very interesting in thinking about how do artists negotiate in ways that are different or parallel or perhaps alternative to the styles of negotiation that lawyers do. This is something that figures quite prominently in my chapter on Christo and Jean-Claude, who were actually awarded Harvard Law School's negotiation prize. I think this happened a few years ago. So,
can you talk about their project?
Yes, so Christo and Jean-Claude, many listeners will be familiar with the Gates project that they did in Central Park some time ago. But their first kind of large-scale project in the United States took place in 1976 in Northern California. So it's about 90 minutes north of San Francisco. It's a very rural location. And their ambition was to have a temporary project that involved basically large curtain-like swaths of white fabric. This was fabric that they had sourced from unused airbags from a car factory. And so they had to ask permission not only from, say, county or city or other municipal authorities, but also the individual farmers that owned parts of the land that they had wanted to use. And that proved to be one of the most challenging, in part because, again, 1976, this is still during the Cold War. Christo, thick Bulgarian accent. Guy who sounds like a communist coming into Northern California, asking, say, a farmer, can I use your land? And thinking, who is this person? And so Jean-Claude actually played an instrumental role because she's French, by all accounts, amazingly charming. Not to say that being French and charming are necessarily correlated, but in her case.
It is.
And she just charmed the socks off of the ranchers who became very invested in this project. And so this is a very good example, again, of how when we think about the law, we also want to think about, say, practices of negotiation, because this project was, like many of Christo and Jean-Claude's other projects, was enabled by a Chicago lawyer named Scott Hodes. Scott Hodes is also the son of a Chicago politician. So in terms of thinking about who one should get to know in order to make a project happen, this is also where lawyers play a really instrumental role. Christo and Jean-Claude had also asked local lawyers in that area of Northern California that they had wanted to use because, again, if you are a county lawyer in a particular neighborhood, you have accumulated relationships with the residents there. And that proved invaluable in realizing this project that everyone said would be impossible. Now, one other thing I just wanted to point out about running fence is that it's indicated as both the work of Christo and Jean-Claude. In 1994, Christo said, "I want all my works to be co-credited to my wife." And this is also something that for me has been a point that perhaps requires further elaboration, is that what about the uncredited labor of, say, family members, especially wives or children, when we think about collaboration? So collaboration is a strategy in artistic practice involving more than one person, is that often one person will get the lion's share of the credit. And so this, going back to this question of, say, intellectual property, how do we, say, distribute or redistribute the credit in such a way that others become legible or recognized? And when I say others, it usually refers to women, people of color, queers, people who are disabled, people who perhaps have been disenfranchised by a system that is very much premised on, again, entitlement. And you mentioned Cameron Rowland. Cameron Rowland, I know, is very influenced by Cheryl Harris, a UCLA law professor who wrote an article called Whiteness as Property. So this is also a book where I'm hoping that we can rethink, say, the history not only of art, but also how is it that law really compels us to think differently about who is actually included in this particular story.
I think that's still the case. It amazes me how many collaborative projects, I guess to back up, copyright and legal structures become an issue only in most cases when there's a dispute, right? So someone has to be upset, they have to feel wronged, and they have to bring it to attention. If that does not occur, then no amount of copyright infringement or contract breach matters, right? Because it's not going to be enforced. And I think you see that in the art world so much on collaborative projects. I mean, I was in Venice. I saw some works of photography, I believe, that the artist said were taken by somebody else. And I was the only lawyer in this group. And I was like, how can this be? You didn't even take these photographs, and your name is the only name that appears on this work. And of course, you're the author of the concept, the inspiration. That may be completely right. But legally, it is messy to have someone else creating your work. And that happens all the time without a lot of interrogation about rights until someone else claims rights.
That seems like the ultimate act of appropriation. And you talk
well, it's willing, so I don't really.
Well,
think it's
but it's complete. It's not. There's no pretense of any kind of transformation.
No, but the concept and the idea come from the artist whose name is on the work. So I think it's a little different.
Right, but as we know, that's not really copyrightable. It's just an interesting way to sort of also look at. You talk, Joan, in your book about appropriation art a little bit, using Rogers versus Coons, the famous puppy case, and others in, again, this idea of artists. We talk about artists who are interrogating the law or looking to the law for protection in terms of their own copyright. But there are also many examples of artists who are challenging notions of copyright and ending up in court. Richard Prince and Jeff Koons, historically.
So I think both Stephen and Katie, you're bringing up two important points. So one is a big issue an issue that I think is just going to get more intense is the debate between what is legally permissible and what is morally viable or ethically viable. A good example might be this year in Art Basel was the LA artist Andrea Bowers. So she had a large work that involved bringing in stories that she had found on Twitter about various incidents of domestic and sexual abuse. And one of the Twitter account holders whose images and stories that Bowers had taken had actually filed a lawsuit saying that Bowers had taken her story without her consent. Now, I am not an expert on Twitter, but as I understand it, if you post something on Twitter, you are voluntarily making that information available. So I am not quite sure if when you post on Twitter, whatever you post becomes public domain, but there is something akin to that effect. However, the pushback that Bowers received after this work was displayed, and I think that pushback was also fueled in part by the fact it was a very expensive work on sale at a very expensive art fair, is that it really forced this issue of, okay, something could be legally permissible. It could have been legal for Bowers to bring these stories, but was it ethical? Was it morally viable? This is a question I think will become more heated in part because, as you mentioned, Katie, that the art world functions on norms. And again, these norms might also be influenced by what people regard as ethical or unethical at a given time. One question, again, to also, I think about with regard to what is ethically viable is that consensus in the art world is difficult to predict and it's difficult to change. And once those sort of norms or approaches are kind of set in place, it becomes really difficult to dislodge, say, certain assumptions that people have in terms of particular works. A good example might be, say, the Dana Schutz painting. Mm-hmm. I mean, for eternity, that painting is just going to be considered for the controversy that it provoked. It will not be written about in any other way. I highly, highly doubt
this
it.
We've mentioned this several times in the podcast, but this was her painting, Open Casket, at the Whitney Biennial, the last Whitney Biennial, that was sort of a cartoonish representation of the photograph of Emmett Till in his casket that his mother had asked to be made widely, publicly available, and was criticized, or calls for its destruction and its removal because of the identity of the artist, not the work, and because she was white.
Yes, that's right.
As we've pointed out before, visitors to the biennial will have noticed that it was full of other representations of violence against people of color. But I think we're continuing to see controversies about what art, should be up. When is offense a good enough reason to take something down or remove it? And you talk about that in your book from the vantage point, of the 60s, 70s, 80s, namely Robert Mapplethorpe, who was involved in all kinds of controversies with both the NEA and lawsuits about obscenity because of his highly pornographic images, mainly of men in sexual positions. And, the art world seemed to be unanimously aligned in defending that work, even though it was deeply offensive to many viewers, especially outside of New York, that kind of censorship, because people were offended no matter how deeply, was completely inappropriate. Do you see a shift? I mean, has there been a norm shift in terms of thinking about the content of art and ethics? And is there a difference between the 60s, 70s, 80s conception of those controversies and what we see today?
I think yes and no. So on the one hand, the basic logic of regarding something as obscene, therefore it should not be made visible, I think that still is very much in play. A recent instance might be, in Japan, this is an incident that literally happened just weeks ago. So there was the Aichi Triennial, so large-scale exhibition, and an artist had exhibited a work that depicted Korean comfort women. So Korean women that were impressed into sexual slavery at the behest of the Japanese imperial government during World War II. Now, the organizers decided to pull that work on the basis that it had created all kinds of controversy. Apparently death threats were made. But the immediacy of that kind of response, without, say, considering what other factors are actually involved, I think this is something that is becoming an increasing issue that curators and, say, artists and increasingly lawyers deal with. But on the other hand, in terms of whether, say, the cultural landscape is more expansive or open-minded. I'm not so convinced of this, mainly because I had a personal incident in which my book had to be published in Thailand, not China, because the Chinese press that normally publishes University of California press books refused to publish the images of Mapplethorpe and Sally Mann that I had.
Oh, that's so interesting.
That was one. And then the other incident was that the general counsel of my own university, at the University of Michigan, advised me to not include any photographs of Sally Mann's work in my book on the grounds that I might be actually put on the sex offenders registry list in Great Britain. Even until, say, maybe 10 years ago, that public exhibitions of Sally Mann's work often brought scrutiny from Scotland Yard on grounds of obscenity.
Yeah. But in the United States, let's say, because I think it's always good to zoom out, because you're totally right that in other countries that dynamic has not shifted. It is not the same. But if we're sticking to the United States and we're comparing the sort of sense of expansiveness and risk-taking and, openness to edginess and, I guess, disregard for who's offended at some point in the cultural production of the 60s, 70s, and 80s to today, I'm just wondering if you see a shift. And I'd also like, in terms of the trends of your book, both the engagement with law, I think, in terms of maybe the more hostile engagements, breaking the law, being more contrary, as you noted, that seems to have shifted into more of an engagement with the law, I think in a much more sophisticated way today, but certainly in a less maybe radical way than before. So if you could sort of talk about that time trajectory.
So my book really ends in the mid-1990s, and one of the main reasons for this is because the scale of the market is such that it now accommodates many, many different kinds of art worlds. So the time period that I'm talking about, this is a time period when artists all sort of knew each other. Now you don't have that situation necessarily. You have all this sort of stratification, so that works that are deemed obscene in some contexts will be perfectly acceptable in others. So I don't think we will ever see the kind of, say, controversy or scale of controversy that erupted when Mapplethorpe's works were proposed to be shown in Washington, D.C. I don't think that intensity of disagreement will necessarily be as, say, prolonged or as amplified. One, because there are just so many art worlds now. Most of the things I talk about in the book, you really can't even do now. So Suzanne Lacy, just to go back to an example, she said, 3 weeks in May, body contract, I could never do those works today, in part because, again, that the idea of risk management, about avoiding blame, about making sure that you align or conform within, say, certain kinds of institutional policies, the structures are in place where you couldn't, say, go and carve a giant hole into the pier of the New York waterfront. That's just not going to happen.
It wouldn't be tolerated. Just like Ann Messner's piece, Stealing, I thought was really interesting that you focused on that. And I don't know whether you could get away with that now.
What's interesting about, say, Ann Messner's work, so this is a work in which she basically put one T-shirt over another, like at a H&M type of store, sort of this kind of like a really low-end Macy's in Germany. And nobody did anything, even though there were surveillance cameras all over the place. And so in some ways...
And she walked out with them.
And she walked out with them.
I don't think that would happen now.
That could never happen now, in part because, again, surveillance has become more intense. This is also, I think, a good segue to talk about some of the differences between, say, art of the recent past versus art now, is that surveillance has become such a major subject in contemporary art, constantly being watched, that the paradigm of privacy has shifted from, again, it used to be privacy was about excluding others from where you lived. Your home was your castle. Now it's about controlling access to the self. And so now you get lots and lots of works that touch directly upon this idea. How is yourself portrayed? Or if you feel that yourself was portrayed in a negative or unflattering light, then you go out and sue the artist who created that presentation. I think that is a market break between, say, art that was made before, say, the mid-1990s, say, early 2000s versus now.
That's an interesting point I hadn't thought about, that one of the differences in the more, let's say, radical, iconoclastic performance art world of the 60s, 70s, 80s is that, let's say you're shooting your friend as an art project and he said, it's fine, go ahead and shoot me. That is probably crazy to most people who hear of it, but it's not on social media, right? I mean, the only people who know about something like that or know about an artwork that's intentionally, explicitly breaking the law are the people who are told about it and see it, right? It's not immediately on social media all over the world. So the kind of risk and scale of doing something like that is so much bigger now because your audience is immediately huge.
The speed at which, say, information is circulated also becomes its own form of surveillance. You have, say, artists who have exhibitions that have a very strict guest list. And this is something I've noticed in, say, places like China, obviously because of government censorship and what have you. But the risk and payoff of being, say, immediately visible. So lots of artists have Instagram accounts. They propagate information about their work that way. But it also makes you more vulnerable in a way that just did not exist in a pre-internet age.
You talk in the book about a rise in the 60s and 70s of a regulation state. There are changes in the legal landscape that, mostly in terms of risk management and liability, that draw artists into interrogating the law. Now, those things are all still true, but there's been a real shift in how artists are engaging with those issues in terms of taking risk. Is part of that not only that some things are just not possible anymore, or our surveillance state and social media make it less appealing, but that the art market that exists today is rewarding a very different type of production and political engagement than was true before. Not to mention that an artist can't live in New York, by making that kind of work in a way that maybe they could in the 70s. I mean, are there other external factors that are changing artists' incentives in terms of how they're engaging with these issues?
I would probably answer yes and no to that. So the means of livelihood have become, say, narrower to a certain degree. So, for example, it is still relatively common to see artists who have their day jobs teaching, for example. But teaching itself has become more precarious as universities downsize. That instead of a full-time tenure track position, you cobble together multiple adjunct jobs to make a living. And so the security that allows you to create work becomes that much more compromised, so that you become more reliant on the market. But on the other hand, it's still true that very few artists can make a living purely by selling his or her work. It's a very, very small percentage. In terms of the market, say, rewarding certain kinds of work, I think that's true. It's one of the reasons why we have tons and tons of abstraction that all looks the same, that are all made by people in their 70s or 80s. I'm complicit in this market. My first book dealt with a body of abstraction, and it became a market phenomenon, which I did not cash out on, unfortunately. But on the other, we also have, say, again, multiple art worlds. So I live in Detroit, where there really isn't an art market. So there are a lot of well-off collectors in southeastern Michigan, but they all do their buying in New York or Basel or Frieze or what have you. They don't buy from Detroit galleries. But that hasn't stopped Detroit artists from, again, creating street art that might get them arrested, or, say, putting on projects that have no, say, commercial value. So I think we do live in an era where these multiple art worlds can absorb some risk-taking. But on the other, if you, say, show in a museum, just to bring up another example in my book, so in 1969, Christo decides to wrap the outside of the Museum of Contemporary Art of Chicago. To my knowledge, he didn't have to sign a whole bunch of waivers or forms. It was pretty freewheeling that the director said, sure, maybe the fire department might say something, but, have a go. Now, if you had an artist attempt even a project a fraction of that scale, you would have to have, say, an army of lawyers, negotiations, insurance like you wouldn't believe. If you show at an institution, the kind of regulation that an artist would be subject to the scale is just much greater than what anyone could have conceived in, say, 1980.
But on the other hand, there are artists today, like there's an artist, Mary Mattingly, who's done this amazing project where she creates these self-sustaining food systems that float around the East River. Dred Scott, who's staging a reenactment of an armed slave rebellion in Louisiana. I actually find that work in some ways much more sophisticated and interesting because those artists are figuring out how to deal with all the stakeholders rather than just ignoring the stakeholders and burning a part of a building. Or, there's something unthoughtful and kind of easy about just destroying someone else's property because you can, and that's the whole point, or taking something because you can, versus building a multi-year project where you're engaging with all kinds of government entities and individual property owners, and then you actually bring it to fruition. I mean, it's mind-boggling that either of those artists can get their projects off the ground, and they do. They don't have teams of lawyers who are helping them. They're just meeting all the stakeholders and, one step at a time, getting the permissions they need. I mean, I can see that some people might say that approach is much less radical and kind of buying into a system where you need to cooperate, but it's in some ways so much more sophisticated.
I would agree with you to the extent that to just destroy property and just call that the artwork, it's just, that is not enough. That's just, it's a gesture at best, right? But I think when you say stakeholders, I think the stakeholders were quite different, say, in particular times versus the present. So for example, with someone like Meta Clark, who was cutting into the pier, he did so at great personal risk to himself. Now, with lots of, say, artists who fall under the rubric of social practice, so meaning artworks that involve, say, communities or, say, have some sort of engagement with society, there already has been many precedents in place, so that if you were, an example from my own locality, Pope L did a project that commented on the Flint water crisis, which involved working with communities in both Flint and Detroit. There was already a precedent for community-based artworks, so it wasn't, say, inventing or reinventing the wheel from scratch, as opposed to someone like Christo and Jean-Claude, for which there was no precedent.
Right.
And so I think the context is just different. So I agree with you in the sense that simply destroying something or urinating in public or violating the law itself, that is not enough to justify a work's existence, or at least it's not enough to make the work compelling. But at the same time, every work has certain kinds of context-specific factors that, again, was there a precedent or a certain historical legacy already in place that would create a space for works for artists like Dred Scott to work in the way that he does? An example would be someone like Theaster Gates.
Right.
Also probably one of the best known in being able to orchestrate different demographics to get to realize what it is that he wants to do. And that itself was, again, based on the row houses project in Houston in the early 1990s. So this is also one of the reasons I wrote this book, is to really emphasize the historicity of these practices, that they all come from these particular lineages, and that no artwork just emerges on its own. So,
Do you see today and going forward more or less engagement with the law and artistic practice?
Oh, definitely more. I mean, I would even go so far as to say that contemporary art is fundamentally shaped by law, that you cannot really be a professional artist with having some basic knowledge of, say, how laws function. And it's not just, say, intellectual property or, say, constitutional law, but anything from labor, from tax, for example. So in my vain attempt to keep up my law license, I had to take all these CLE credits, but my favorite one was a class on protest lawyering. So how do you find or identify tactics of negotiating with police to keep your client from being arrested? But these are ideas that also artists, I find, have been gravitating towards when they make work that has some kind of message of political dissent. Right?
Well,
thank you so much for talking to us.
thank you, Joan.
Thanks to both of you for having me today.
And we will obviously post a link to your book in our show notes where people can find it and find out more about you and your work.
Right. Thank you very much.
And that's it for today's podcast. Please subscribe to us wherever you get your podcasts and send us feedback at podcast@schlaw.com. And if you like what you hear, give us a 5-star rating. We are also featuring the original music of Chris Thompson. And finally, we want to thank our fabulous producer, Jackie Santos, for making us sound so good.
Until next time, I'm Katie Wilson-Milne.
And I'm Steve Schindler, bringing you the Art Law Podcast, a podcast exploring the places where art intersects with and interferes with the law.
The information provided in this podcast is not intended to be a source of legal advice. You should not consider the information provided to be an invitation for an attorney-client relationship, should not rely on the information as legal advice for any purpose, and should always seek the legal advice of competent counsel in the relevant jurisdiction.